Welcome to another episode of Off the Record. Today I'm joined by Deirdre Venter. She is a partner in the Employment Law Department of Shepstone and Wiley Attorneys. Deirdre is a full-spectrum employment attorney whose expertise has been recognized in the 2025 Best Lawyers Awards. Deirdre also frequently sits as an acting judge in the labor court, and she is an avid animal lover and owner of 15 guinea pigs. Deirdre, thank you so much for joining us today.
Thank you, Anati.
So today, Deirdre is going to be taking us through what our courts have described as a scourge in the workplace, and that is sexual harassment. This is a very sensitive topic, but it is important for everyone, both employees and employers, to know exactly what their obligations are so that we can do our parts in making sure that our workplaces are rid of this issue. Deirdre, to start us off, I think it's important for you to help us understand what exactly is sexual harassment.
Unati, sexual harassment really is, in essence, unwanted conduct of a sexual nature that impairs the victim's dignity or creates a hostile work environment for the victim in the workplace.
So how would I know that, someone's conduct in the workplace is sexual harassment? Is there a way to prove it or test it so that we're all on the same page as to whether or not what I feel I'm complaining about, reaches the mark of what is considered sexual harassment?
Unati, the test for sexual harassment, if you as an employer have received a complaint of sexual harassment and you need to determine whether or not the complaint meets the definition of sexual harassment, you would basically really look at whether or not the conduct is unwanted or unwelcome. In order to determine whether the conduct is unwanted or unwelcome, the Labour Appeal Court has endorsed a subjective test where the employer is to look at how the victim of the sexual harassment perceives the conduct and whether or not that perception of the victim is reasonable. The Code of Good Practice on the prevention and elimination of harassment in the workplace endorses a subjective and an objective code. So that would be that in absence of the victim actually expressing that the conduct is unwelcome or unwanted, the test would then be whether a reasonable person in the position of the victim would consider the conduct to be unwelcome or unwanted.
Okay. So let's say I'm an employee and a fellow employee, approaches me in a way that I'm not comfortable with. Does that mean that it has to be a physical approach, or is there, another form of harassment that I, can be free to report to the employer?
Yes, Nati, there's a number of forms of sexual harassment. So sexual harassment does not necessarily have to be physical. Physical would be your unwanted, unwelcome touching, groping. Sexual harassment could also take the form of verbal, inappropriate comments of a sexual nature. It could also be general in the sense where you are harassing me or making inappropriate comments on social media, for example. It also could be where you are demoting me as an employee, or you putting me through disciplinary action that's not warranted because I'm not succumbing to your sexual advances. So sexual harassment can take various forms. It does not necessarily have to be physical. There's also various forms of sexual harassment, such as quid pro quo sexual harassment, where you've got a employee that's being harassed by somebody who's in authority, and if she or he doesn't succumb to the harasser's sexual advances, that person may face demotion. Or quid pro quo is really the sense of succumb to my sexual advances and I will benefit you, I'll promote you, I will provide you with benefits in the workplace. You also get hostile work environment harassment, where the harasser is making the actual victim's work environment hostile. And then you get sexual favoritism, which is while you succumbing to my sexual advances, I will favor you in the workplace.
Okay. So as an employee, do I have to report to the employer if I feel that I am being harassed by another employee?
Unati, there's no legal obligation on a victim of harassment to report the harassment to an employer. However, if a victim of harassment does report, the employer then has an obligation to immediately attend to the complaint.
Okay.
and address it.
And how does an employer do that once they have received such a report?
Well, once an employer receives a report of sexual harassment, there are a number of duties on an employer in terms of the code. The duties are to counsel and provide the employee with assistance if the employee needs. There's a duty to consult the parties involved, and there is a duty on the employer then to take all reasonable steps to prevent the reoccurrence of the harassment and to eliminate the harassment in the workplace. Employers have an obligation to create working environments and a workplace that are free from harassment and can be held liable should they not do, or should they fail in those duties. So if an employee has reported harassment, it has come to the attention of the employer, and the employer fails to take steps, the employer could ultimately be held liable for the sexual harassment.
Okay. We've been talking a lot about the term workplace at work. What constitutes a workplace? Does sexual harassment only happen if I'm on duty or at my desk? Or can it still be sexual harassment if, let's say, we're at a year-end party as colleagues?
Yes, definitely, Unati. The actual definition of workplace for purposes of the elimination and prohibition of harassment in the workplace is quite wide. So it will include my physical offices. It will definitely include social events. It will include remote work, and it would include functions. So wherever the employees are within the work environment, the employer has got a duty in those circumstances to avoid or to prevent sexual harassment from taking place. And that is one of the important duties an employer has, is an employer needs to do a risk assessment of the possibility of any potential harassment taking place in the workplace. And that would include the employee's physical offices, any work events, travel events. So if, for example, if an harassment takes place at a hotel and it's a work-related event, the employer could possibly be held liable if it didn't take steps to eliminate the harassment in those environments.
Okay, so that's actually quite wide, because I think, the misconception is that a workplace is bound to our traditional understanding of what an office is, which is usually, what we consider to be a workplace.
No, not 100%. And it could even extend to online communication between employees. So not just the physical offices or, for example, social events. It could be online communication even between employees. That would also be regarded as a workplace.
Okay. So you mentioned that counseling is, part of how an employer needs to deal with reports of sexual harassment. Does that mean that it just ends at counseling? Does the matter escalate in the event that the counseling fails? Or, what if I as an employee feel as if the employer is not doing enough? Does it just end at that mediation session, me getting that, psychological assistance, so to speak, from the employer?
No, it doesn't. So, Unati, there's an obligation on an employer when a report of sexual harassment has been made to it, or it's become aware of an incident of sexual harassment, to consult the parties to see whether or not there is a resolution. If there could be no resolution, the victim of the sexual harassment must be guided to take the complaint further, either in terms of the employer's formal or informal grievance procedure.
Okay.
That would normally involve, typically, an investigation by the employer with the assistance of a neutral person, objective person, who will come in and investigate to see whether or not there is any merit in the allegations of sexual harassment that's been raised by the victim.
Okay. So this is where attorneys come in, I suppose, because, in a lot of instances of sexual harassment, we see the involvement of attorneys either at an investigation stage or at a hearing.
Yes, Unati. So where an allegation or where allegations of sexual harassment have been made and the employer now needs to investigate those allegations, generally it is advisable for employers to bring in neutral objective individuals who can come and investigate the allegations. The reasons why a neutral objective person is important is because the employer has another duty, to create an environment where victims of sexual harassment feel that the complaints are not trivialized, will not be ignored, and they can make these complaints without fear of reprisal.
So a safe space.
Yes, the employer must create a safe space, and if there is an investigation into allegations of sexual harassment, an objective person who will come in and deal with the allegations and the victim in a sensitive, confidential manner would be in compliance with that duty that the employer has.
Okay. And how do employers make sure that their policies align with all of these requirements? You know, so let's say you're an employer, you want to make sure that your policies, A, are correct. They also align with what the code and, you know, the international law expects of an employer. You know, where to from here?
Well, the potential liability for employers for sexual harassment committed by its employees is significant. If the employers do not comply with their obligations, there are numerous obligations on employers in terms of the Code of Good Practice, which is to be read with your Employment Equity Act. Those obligations are quite onerous. One of the main obligations is that employers need to have policies that regulating sexual harassment and harassment in general. And this is how employers can take steps to prevent and avoid possible liability should there be incidents of sexual harassment in their workplaces. So where to from now? Employers must ensure that their policies on sexual harassment are compliant with the code and give the victims of sexual harassment all the tools and measures available to them that is encouraged in the code.
Okay. Deirdre, thank you so much for taking us through what is quite an important topic, but understandably equally sensitive for both employees and employers in dealing with it. If you as an employer feel as if your policies are not aligned or they may be short here and there, Deirdre is really the correct person to reach out to so that she can review and ensure that your policies are aligned with the code. And so you can do your bit as an employer in making sure that not only are you creating a safe working environment, but you are ensuring that the scourge of sexual harassment is evaded in the workplace. And Deirdre, thank you once again for your time. Please join us for another episode of Off the Record, where we'll be having another special guest taking us through all the relevant topics of employment law.